Well, good afternoon, everybody. I'm Jason Sneed, a policy analyst with the Heritage Foundation, and I'm delighted to be able to attend CPAC this year with a terrific panel of experts. We're going to be talking about something which is unfortunately sobering but important, and that's property rights. And before I turn it over to our distinguished panelists, I'd like to help to frame the issue a little bit. Property rights were something that the Founding Fathers were deeply committed to. In fact, as James Madison put it, where an excess of power prevails, property of no sort is duly respected. No man is safe in his opinions, his person, his faculties, or his possessions. The framers viewed property rights as natural rights that were indistinguishable from and were fundamental to our other freedoms like speech, expression, and religion. The ability to own property, to own your own labor, and to enjoy the fruits of that labor was seen as the basis of a free society. And so therefore, it's only natural to conclude that one of the most important functions of government should be the protection of property rights. 2 centuries later, though, we see many threats. Some of them are over the horizon and yet to emerge, others taking place right now, that challenge the sanctity of private property. And unfortunately, a great many of those threats emanate from the government itself. So I'm excited to be able to engage in a discussion today about this issue and some of the challenges facing property owners in the 21st century. That's ranging from the police seizure of property and money under civil asset forfeiture laws to calls by many to weaken or even eliminate rights to intellectual property. So I'll start by introducing the panelists here today. Speaking first will be Hal Stratton, former Attorney General for the state of New Mexico and the 8th Chairman of the Consumer Product Safety Commission. Next, we'll hear from Clark Neely. Clark is an attorney and author with the public interest law firm, the Institute for Justice. Up next will be Maureen Olhausen, currently serving as a commissioner on the Federal Trade Commission. And last but certainly not least is Dr. Gregory Dolan, a professor and the co-director of the Center for Medicine and Law at the University of Baltimore. Al?
Well, I'm going to talk about civil asset forfeiture. So this is going to be 30 years of civil asset forfeiture in 5 minutes, so bear with me. First, civil asset forfeiture is a procedure by which law enforcement agencies can come seize property that they believe has been involved in a crime without charging anybody or convicting anybody. And they proceed against the property, not against the individual. And it's become a big, huge problem in our country. A lot of innocent people have had their property seized. 2 things exacerbate this. Number one, when the law enforcement officials seize that property, they keep the property in the police department or they keep the proceeds and they get to then spend that money. It's not appropriated. There's no oversight to it. In New Mexico, we don't know how they spend it and we don't know how much it is. The other problem is what they call equitable sharing. And the federal government back in the 1980s set up a program where if they forfeit the property, in other words, if the local government gives it to the feds and there's a federal crime that can be alleged, they'll forfeit it and kick back 80% to the law enforcement agencies. And law enforcement agencies have come, unfortunately, to rely upon this for revenue. Now, how did this get started? Back in the 1980s, we were fighting crime, we were fighting drugs. I was in the legislature. I had a friend who was in the legislature with me who went to the Reagan Justice Department and ran the program for asset forfeiture. He called us up, he said, listen, we can do this. We can figure out a way where you can start forfeiting civil property. We'll get it against the drug dealers and it's the criminals. It'll be a great crime fighting thing. So we did it. And we thought it was a good idea. We were all into crime fighting in those days. We were all against crime. I went on to the Attorney General's office after that, didn't think anything about it. We never used it, never came up, wasn't a big problem. Brad went on someplace else. So fast forward for 30 years, and we would hear about these horrific situations where people would lose their property. The courts would make decisions where innocent owners couldn't assert their rights in the proceedings, and things started getting out of whack. So Brad and I found ourselves back in New Mexico again, our home state, and at the legislature. And Brad had decided we've got to do something about this. He ended up being the chief staffer on the Judiciary Committee, and we won, the Republicans won the House in New Mexico for the first time in 60 years last year. So he got to work for thank you. It was a long haul, and we hope we can keep it. But anyway, he drafted the bill up. I was hanging around just as a lobbyist and trying to help on this because we felt very bad that we were guys that were somewhat responsible for putting this in place. Went to one committee hearing, and here's the key to the whole thing, is I testified for the repealer, the ACLU testified for the repealer, the Drug Policy Alliance testified for the repealer, and the Rio Grande Foundation, New Mexico's free market think tank. And then the Speaker of the House, who was the new Speaker of the House on the committee, made the motion to pass the bill, and it passed unanimously. I knew at that point, we hadn't even lobbied him, that we were in pretty good shape. We then passed the House unanimously. We then went to the Senate. There wasn't another hearing. They consented it out, got it out the last morning, and got it out unanimously. We couldn't believe it. We didn't really think we had a chance when this started. So I'm telling you, everybody has a chance, so give it a try. The governor had 20 days to sign the bill, and I want to thank the Institute for Justice and Heritage and Cato and Grover Norquist at ATR. Everybody weighed in on it for us with the governor, and on the last morning, she signed the bill. And so we repealed civil asset forfeiture in New Mexico. So at least that property is going to be safe as they're traveling through New Mexico. Now, in the follow-up, because my time's up, I'm sure, so in the follow-up, you think we're done now, right? We're not done. There's a sequel to this, and I'll let you sit and think about it and think about whether we're done or there's more that needs to be done until the questioning. Thanks.
Thank you. Clark?
America is the most prosperous nation in the history of the world, bar none. It's not because we're smarter, more virtuous than people in other countries. It's because the founders of our country got something right from the beginning, and that is the sanctity of property rights. That is the idea that's woven into our Constitution, that the government may not take from you what you have lawfully earned without a very good reason. By the way, that's what's in the Constitution. That's not how policy is today. And civil forfeiture is an example of the wholesale abandonment of the sanctity of property rights as reflected in the Constitution. And by the way, it's not just the Constitution. It is no accident that about 1/3 of the 10 Commandments have to do with property rights in one form or another, talking about not stealing and not coveting what is not yours. What about our government today? Does our government steal what does not belong to it? Does our government covet what belongs to us? Absolutely. And civil forfeiture is perhaps one of the most grotesque examples of this covetousness on the part of government that I'm familiar with and that I've encountered in my 16 years as a public interest lawyer. I will stand here before you or sit here before you and tell you that in my judgment, civil forfeiture is the most corrupt and corrupting policy in America today. It enables law enforcement to take from honest, law-abiding people property that they have earned, money that they are using to run their business or put food on their table for their children, and to take it, as Hal said, without so much as charging you with a crime, let alone securing a conviction. They are able to take that property from innocent, law-abiding Americans on the basis of nothing more than probable cause, which has come to mean nothing more than a hunch, and then good luck trying to get it back. You'll hear defenders of civil forfeiture tell you that, you don't need to worry about civil forfeiture being used to take property from innocent people because there's a process that they can use to get it back. Well, there is a process, and that process makes the tax code look like a children's nursery rhyme. How do I know? Because I litigate civil forfeiture cases, and I have tangled with the government, and I'm happy to say we've gotten the property back every time, but that's not because we're so good. It's because the policy is so blatantly abused that not even the government can defend it when good lawyers get involved. But that usually doesn't happen because the average law-abiding, hard-working American doesn't have a lawyer on speed dial. They're not going to be represented in court when the government comes to take their stuff. Unfortunately, civil forfeiture is only the tip of the iceberg. As we know, there are all kinds of other ways in which the government covets our property and takes from us what we have earned and what belongs to us. And I just want to briefly touch on one other example for those of you who are familiar with the term eminent domain. Probably familiar with it from a case from 2005 called Kelo versus City of New London that my organization, the Institute for Justice, litigated. In that case, the issue was, and I am not making this up, the issue was whether the public use provision of the Fifth Amendment that says the government may only take your property using eminent domain for a public use like a road or a school, whether that provision permits the government to take homes and businesses in a working class neighborhood, bulldoze the entire neighborhood and convey that property to a predatory corporation, in this case Pfizer, to build Yuppieville. And by a 5-4 margin, the US Supreme Court said that's just fine. Fortunately, there was a tremendous backlash against Kelo. The people of the United States raised up and expressed their dismay and their frustration. It is the most widely reviled case in the history of the United States, and that is a further example of how the courts have abandoned property rights.
Thank you, Clark. And I'd like to take a second and commend the work that the Institute for Justice does in litigating some of these forfeiture cases. There are people who, were it not for them, they would be destitute, they would not have a house, they would not have a car. They do some fantastic work on civil forfeiture. Maureen?
Thank you. Well, it's a pleasure to be here at CPAC again to discuss the critically important issue of property rights. It's no exaggeration to say that property rights are the cornerstone of liberty. Our founding fathers recognized that truth, which remains as valid today as it was then. Anyone doubting that proposition need merely think of despotic regimes around the world. In such countries, people have no recourse against theft of their property, whether by the government or by their politically favored neighbors. In America, we work for what is ours, and the law protects ownership rights accordingly. But even property rights are not immune to the political winds of the time. In some quarters today, activists call for large-scale wealth redistribution through punitive taxes. But incursions into ownership rights take many forms. Civil asset forfeiture can be problematic, as Hal explained, and so too courts must protect owners against improper takings by the government, as Clark has so eloquently laid out. I wish to address a different but equally important topic in property law, and that's the role of patents and intellectual property in driving US innovation. Although patents seem far removed from ownership rights in your home and car, the principles are remarkably similar. The overriding belief is that owners should have the ultimate say in how their property is used. So like Thomas Edison and the Wright brothers, inventors today toil to uncover new insights, and companies spend billions of dollars on research. When society awards an innovator a patent for a novel, useful, and non-obvious discovery, others should not be able to use that information free of charge. Just as your neighbor may not take your house, so your competitor cannot copy your patented technology. Not only is it right to protect ownership interests in technology, doing so is critical for US innovation policy. The US economy is and has long been the most innovative in the world, and that is no accident. It reflects the long-standing, constitutionally recognized need for intellectual property rights. Yet the patent system today faces an unprecedented threat, especially from the left. Some economists, academics, and policymakers have even called for the outright abolition of the patent regime. Others want to dilute patents so that many inventors can no longer effectively enforce their rights. And that is folly. Defending strong intellectual property rights is not simply a moral imperative, it is critical to protecting US innovation. A recurring claim from the left is that conservatives support the patent system blindly without regard to evidence. And I'm here to tell you that that is not true. There is powerful evidence and theory supporting the need for strong intellectual property systems. For those who would abolish patents are the ones who cannot prove their case. I recently studied the large economic literature on the relationship between patents, R&D investment by private firms, and economic growth. And my article will be published in the Harvard Journal of Law and Technology, and it finds abundant support for robust patent protection. At the country level, there is overwhelming evidence that patent strength correlates positively with R&D expenditures and economic growth. So what does that mean? Countries like America that generously protect their inventors tend to have stronger economies. They also tend to have companies that spend more on innovation. And there's much other evidence as well. And research shows that without patents, innovation in critical areas of the economy, like pharmaceuticals, would grind to a halt. And I understand that Professor Dolan, who has expertise in this area, may have more to add. Now, as with everything in life, of course, the intellectual property system today is not perfect. There is some evidence, for example, that the Patent and Trademark Office sometimes makes mistakes awarding patents that it shouldn't. Yet the Supreme Court has recently limited the harm caused by weak patents, and that is the right approach. Deserving inventors warrant strong protection, but those who claim obvious ideas do not. So to conclude, the anti-patent crowd is wrong. We need to honor property rights in all of their forms, whether it be in your house or your car or your invention. So thank you for your attention, and I look forward to the discussion.
Thank you. Greg?
Thank you very much for having me here. I want to echo much of what has been said before, but I'll begin with a personal story. I grew up in a former Soviet Union, and I came here when I was 13. My dad was an engineer in the Soviet Union, much like he's an engineer today. And the question is, why did the Soviet Union lose the Cold War? Why did we win? Is it because the Soviet engineers were dumber? They were not. My dad was an engineer there, and he's an engineer now. Is it because people didn't understand technology? No. It is because people there did not have private property rights. There was no incentive for them to innovate. My dad, who has a number of patents to his name back in the Soviet Union, he got no rewards for them other than a token few rubles at the end of the month when he got his patent. It didn't matter whether his patent actually brought any benefit to the public or whether it did not. The reward, the token rubles, was exactly the same. So sure, he filed some applications because some rubles are better than none, but he did not care whether or not actually his innovation does something good or does not. Things are different here. One of my good friends that I went to law school with once told me that he visited the former Soviet Union back in the mid-'80s. And because he was an American high school student, they took him all around, including to one of the offices of high party official. And he said, even back then, in the mid-'80s, he was stunned because on the desk of that high party official, there were 5 different telephones. He said, why can't you just have one telephone with 5 buttons for each line? Because they didn't have the technology. Why didn't they have the technology? They had no incentive to innovate to provide the technology. So they had 5 different phones. The reason we are successful, the reason we won the Cold War, the reason we are the best and most prosperous country in this world is because we protect private property rights, from your house to your patents. And I know patent law is not something that gets people's blood boiling, and yet sometimes it should, because Congress has been on a rampage, and I'm sad to say that both Republicans and Democrats have been bamboozled by anti-patent people. They've been bamboozled by people who think patents are the problem. They've been bamboozled by this idea that only if we weaken patents, we'll have cheaper drugs. And maybe, yes, we will today. But that means you're not going to have the drug to cure cancer tomorrow. And they've been passing laws, and they've been considering bills to weaken the patent system, and that must stop. Or else, we're going to trade cheaper drugs today, which is, by the way, not unimportant. But we're going to trade cheaper drugs today for us, for the drugs and technology and the better phones that will help our kids, that will help our kids advance, that will help our kids have better lives than we do, that will help our kids conquer various diseases. And that is, I think, where we should focus. Now, I completely agree with Maureen. Yes, there are bad patents, and yes, there are bad actors. But just like there are bad actors in everything, there are people who use guns improperly. But do we ban guns? Well, perhaps the other side would, but we shouldn't. Right? There are people who use patents improperly. There are people who use their cars improperly. People who drive drunk. Do we ban cars? We do not. And same thing, same logic should apply to patents. Simply because there are few bad actors here and there is not a reason to abandon, not the reason to slaughter the very goose that keeps laying the golden egg and has been doing it for the last 200 years.
Thank you all for those remarks. I think those were incredibly enlightening. I'd like to begin a discussion with a question for all of you. We are obviously in the midst of a political cycle, and we've seen the issue of property rights come up in some unusual ways. We have one candidate that believes in a strong eminent domain power so that the government can seize property for purely private development, essentially. And then on the other hand, we have somebody critiquing the entire capitalistic system and calling for a weakening of property rights for everybody in the name of so-called economic justice. Both of these candidates have won broad support in the electorate. So does that suggest to you that Americans are losing interest in private property or in the defense of private property rights?
I would hope not, but I think the part of the problem is, again, people are oftentimes being misled by false statistics, because if you say something with conviction and throw out big numbers, all of a sudden it seems like a problem. If you get out there and say, patents actually cost our economy $20 billion, and supported by poorly done studies, people start scratching their heads saying, well, maybe it's a problem. The problem is not that people are losing faith in private property. The problem is that they're being misled by academics who are not doing a very good job. They're being misled by people who are promising them all the goodies of cheap drugs without telling the cost of no drugs later on. And people say, well, if I can get cheap drugs now, why not?
I think most of us take it for granted, too. I mean, we take our private property rights, we take all of our civil liberties, we take the Bill of Rights completely for granted. It's there. We've protected them for almost 200 years, or some semblance of them, at least. And I think people, and not many people are subjected to condemnation or eminent domain. Not many people are subjected to having their car being pulled over and having their car taken away from them by the police. So I think we're so much into our everyday lives trying to make the system work, and I think justifiably, that I just think maybe we're taking it for granted too much, but the time is coming when we better wake up.
Well, look, the first eminent domain case the Institute for Justice ever had was when Donald Trump tried to take a home belonging to a widow named Vera Koking in Atlantic City. It wasn't the people of New Jersey that went in to help him do that. It was the Atlantic City City Council that Donald Trump went to and said, will you use your eminent domain power to take this woman's house? And they said, yes, absolutely. And it was the judiciary that forced him to back off. So there are two important points there. One is, it's not the people who are interested in violating each other's property rights. It is the government that is manipulated into doing it. That's point one. And second, we need a truly independent judiciary to say no when our politicians denigrate the property rights that are enshrined in our Constitution.
My expertise is really in markets. And the issue of property rights is fundamentally intertwined with the idea of free markets in the US. That's the foundation of our economic system. So I think that we need to kind of reestablish that link, that the reason you have your property right and the free market working together so well is the owner gets to decide whether to enter that market, whether to sell that right, and at what price. And I think that those two things are so important to be reconnected, because fundamentally that's the point of our economic system and our political system, is this liberty kind of approach.
Hal, you alluded to this in your remarks, but you know, the great work that you guys did in New Mexico to end civil forfeiture, that was not the end of the story. There's a sequel going on right now. Would you like to give us the rundown on that?
Well, yeah, thank you for that question, because it's not over. Some things come up after you win the fight. The first thing that came up was the city of Albuquerque decided they were exempt from state law and that they were going to continue to forfeit cars in DWI situations. And not only that, they bought a whole new facility to keep the cars in. They were forfeiting so many. And thank goodness for IJ, the Institute for Justice. They came in and have now sued the city of Albuquerque, and they got 2 state senators, a Democrat and a Republican, to try to stop that practice. So that's number one, the local governments. And we didn't have a straight preemption provision in the statute, but I think under typical state law, they would be preempted. Number two is that you're going to see it come up again. The bill was introduced again to reinstitute civil asset forfeiture in this legislative session, and it completely undid all the good that we did. But the good news was it was a financial session, and they needed a message from the governor to get that through the legislature, and they didn't get the message. So thank you, Governor, for not giving them a message this time. I expect we will see it next time. And then finally, and this one was one you'll never guess, is after the law went into effect, some of the law enforcement agencies started taking the property they had forfeited and dumping it on the state treasurer's steps in front of the state treasurer's office, saying, well, we don't get to keep the money anymore, you guys deal with it. Well, the state treasurer didn't have any mechanism to deal with that, so what did he do? Well, he went to the legislature and asked them to increase his budget so he would have more money to deal with the forfeited assets. So you're going to have to watch out for that. So the battle isn't over. We got a lot more work to do, and I hope every one of you in every one of the states out there will see what you can do about this, because as Clark said, this is easily the most obvious violation of civil rights that I think is going on to the average citizen out there.
Well, Clark, you mentioned that, obviously forfeiture is not the only way that the government can take your property. You've got the eminent domain power as well. Those are obviously two unrelated powers. But in the eminent domain space, it's in the Constitution. There has to be an eminent domain power. You can make a good argument for it. But where do you draw the line between a legitimate use of that power and an illegitimate use of that power?
Yeah, so to be clear, the Fifth Amendment to the Constitution provides that private property shall not be taken for public use without just compensation. So this implies a power of eminent domain, and it's a power the government needs in some settings. You can't build a highway zigzagging around every property that somebody doesn't want to sell, but you have got to draw the line in a place that protects the institution of private property rights so that as Justice O'Connor, believe it or not, of all people, warned in her dissenting opinion in Kelo, that if you rule the way the Supreme Court does, there is not a church, a home, or a small business in America that could not make more money as a strip mall or a giant corporation. So what you do is you draw the line in a place that makes it impossible for these predatory businesses and people who want to pervert property rights to take what doesn't belong to them for a non-public use, for something that is not a road, is not a hospital, is not a school. The line drawing is not that difficult in these cases. When you have Pfizer lobbying the New London City Council to bulldoze an entire neighborhood for homes for Pfizer executives, I'm sorry, that's not a hard case. So we get the easy cases right, and then we worry about the line drawing problems later.
I'd like to pivot for a second to the intellectual property space. We've all heard of some of the famous patent cases that deal with something like a rectangular phone with rounded edges, something like that. That idea doesn't necessarily seem particularly novel. So my question is, do you think it's too easy to get a patent today?
Well, I don't necessarily think it's too easy to get a patent overall. I do think that there are instances where patents have been granted inappropriately or too broadly. The question is, what is the response to that? Do you just devalue all patents? Do you just sort of make intellectual property law not a respected right anymore? I think that there are processes to make sure that patents are appropriate, and there have been new steps in the law to do that. I'm afraid that arguments that some patents are too broad or some patents are too easy to get are being used as a way to undermine all patents.
And I agree with that. After all, of course there are mistakes going to be made. After all, who actually examines the patent applications? These are government employees. Yes, they may make mistakes just like they make mistakes in other areas where the government is involved. Not to cast aspersions on all government employees.
Thank you.
But yes, there can be mistakes, but we have processes, we have judges, we have litigation. Nobody says that once the patent is granted, it should be valid forever without a challenge. But by all means, bring a challenge to a court. Prove your case that the patent was granted improperly, and invalidate it, that it's not going to be asserted against anybody else. But you can't just say that that proof has to have some sort of standard. It cannot be very easy to invalidate a patent because people have poured their life savings, they've poured their efforts into getting it. And just invalidating them willy-nilly is a problem. That's what's going to retard innovation at the end of the day.
Well, I'd like to take just the remainder of our time here to ask you all a question that will give you a chance to get out of the particular areas that you've been talking about. Looking ahead, 5 or 10 years, what do you think the biggest challenge to property rights will be?
I think one of the biggest challenges is something that I've already seen. So as part of my job, I've gone to China 6 times in the past 2 years. And what we are doing to devalue property rights here is echoing around the world. So other countries are looking and saying, wow, we would like access to US technology. Boy, we'd like to just be able to copy that. And we are just doing what you're doing in the US. So whatever we do here has ramifications around the world.
I would echo that.
Oh, thank you.
I think that the biggest problem we have is that property rights are enshrined in our Constitution, but not by and large enforced by our judiciary. For the last 40 or so years, we've had a judiciary that has rendered property rights what they call non-fundamental, meaning meaningless. And we're at a turning point. Either we're going to have a Supreme Court that respects and protects property rights the way the Constitution does, or we're going to have a Supreme Court full of yes men and yes women who simply rubber stamp whatever the government does, as they did in Kelo. That's the break point for us.
I'll echo what Clark says, and I will just say the biggest threat to our property rights is our government. So we need to make sure we elect the right people if you can, and make sure you get the right judges in place.
Well, that does it for our panel today. Please join me in thanking our panelists for their fine remarks.